The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
You may be seated. Is the Reisinger?
Thank you, Your Honor, and may it please the court. Nathaniel Reisinger, court-appointed counsel for the movement Randolph McNeil. I'll reserve 4 minutes for rebuttal. This case asks whether the district court may even consider a challenge brought by an individual who is subject to an unconstitutional conviction for conduct that is no longer criminal. Under Section 2255's provisions on successive motions, or in the alternative under its savings clause, the answer is yes. When the Supreme Court decided Rahafe versus United States, it established for the first time that a criminal defendant's constitutional rights are violated if he is subjected to a conviction where his knowledge of status was not included in the indictment, not presented to the jury, and not proven beyond a reasonable doubt. Before Rahafe, a conviction was constitutional even if it were not supported by each of those things, and after Rahafe, it isn't. Rahafe thus announced a new constitutional rule, previously unavailable in this circuit, which the government no longer disputes was made retroactive to cases on collateral review. A Rahafe error accordingly satisfies the standards for a successive 2255 motion for authorization to file.
Well, in your only form of relief under 2255E, the savings clause, which then triggers a 2241.
We have argued, Your Honor, in the alternative that if Rahafe did not announce a new constitutional rule, then he can't satisfy the gatekeeping provisions of 2255. But our primary position is that Rahafe did announce a new constitutional rule, which allows him to proceed under a successive motion under 2255H2.
Well, it was certainly a substantive change in the law, just adding an element, but that didn't make it a new constitutional rule, does it?
Yes, Your Honor, we think it does. And the reason for that is because when the Supreme Court interprets a new element, interprets the statute to include an element that was not previously interpreted to be included in the statute, it changes the class of individuals who can be constitutionally subject to a conviction under that statute, and it alters the scope of conduct that can be the basis for a constitutional conviction. So it's certainly the case that not every question of statutory interpretation has constitutional implications, but the addition of a new element that the government is required to prove beyond a reasonable doubt does have substantive constitutional implications, because it changes whether or not a defendant can be constitutionally convicted under the statute. And it's undisputed here that Mr. McNeil's knowledge of status was not included in his indictment, not presented to the jury, and not proven beyond a reasonable doubt. So as a result, he is currently subject to a conviction that the Constitution does not permit following Rahafe, but did permit before Rahafe was announced. And that satisfies the showing on a motion for authorization that there is a new constitutional rule.
What about in re viol?
So in re viol, I think it's important to distinguish between the nature of the statutory interpretation question. So in re viol, which interpreted the Bailey decision from the Supreme Court case, the Bailey decision from the Supreme Court, changed the interpretation of what was required to prove for use of a firearm. It didn't.
Thank you.
So.
What part of 922G the court would you say is unconstitutional in light of Rahafe?
I'm so sorry, Your Honor.
Part of 922G would be unconstitutional.
So our position is not that 922G is unconstitutional. It's that.
You're not dealing with the unconstitutionality. What you're dealing with is the statutory interpretation, as was done in Bailey, which Bow says that's not a constitutional change.
So the difference is between Bailey and Rahafe is that in Bailey, the Supreme Court altered the interpretation of a pre-existing element of the criminal statute. Here, the Supreme Court has interpreted the statute to include an entirely new element. And that distinction, I think, presents a clearer break.
Listen to your words. Interpreted the statute to include. You didn't say held it to be unconstitutional not to include.
I think Rahafe, the implication of Rahafe is that it is unconstitutional to convict a person unless each of the elements that the statute requires was proven beyond a reasonable doubt, presented to the
Constitutional provision.
the Fifth Amendments, the Fifth and Sixth Amendments, the right to have the proof presented to a jury.
Rahab mentioned that.
No, Your Honor, it didn't, and we don't think that it needed to.
Any case ever said that was the basis upon which, when you're interpreting a statute, that then you look at it by implication as an unconstitutional interpretation?
I would point to Summerlin versus Shriro, which established that when you change the class of individuals who are subject to the statute or alter the course of conduct such that individuals can no longer, that individuals are incarcerated for or subject.
There's no other circuit that's as held as what you want to hold, has it? I mean, every circuit that's looked at this has said that Rahab didn't announce a new constitutional rule. Is that correct?
Yes, Your Honor, that's true. And
First time ever anybody's ever said that.
it would be the first time that a court has held that Rahafe announced a new rule of constitutional law in the context of a successive 2255 petition. The Fifth Circuit and the 11th Circuit have both held that it announced that it created new substantive constitutional rights in the context of an initial 2255 petition. And simply put, we think those prior cases to hold that Rahafe did not announce a new rule of constitutional law are wrongly decided. The clear implication of Rahafe is that
Circuits are absolutely wrong, you see.
yes, Your Honor. When the Supreme Court interprets a statute to include an element that was not proven in the defendant's case, the situation we have is a defendant who is subject to an unconstitutional conviction for conduct that is no longer criminal. If the court's not persuaded that Rahafe announced a new constitutional rule, it flows from that decision, I think fairly straightforwardly, that he ought to be allowed to proceed under the Savings Clause of 2255E and file a traditional habeas petition under 2241. At the time of his conviction, circuit precedent under Lockhart and Langley expressly held that the government was not required to prove his knowledge of status.
You got a lot of support in Jones on that.
Yes, Your Honor.
But do you need this court to authorize this, or is this something you can get in district court?
As a strictly procedural matter, Mr. McNeil does not need the authorization of this court to file a 2241 petition under the Savings Clause. But in Ray Jones, the same was true in Ray Jones. The petitioner there didn't need the court to weigh in on whether he could file 2241. He would have been free to do so and raise the same arguments. This court's decision in Ray Jones, however, served the important values of efficiency when we're talking about post-conviction relief and habeas cases, especially when we have an individual who is subject to an unconstitutional conviction for conduct that's no longer criminal.
But you can make this application directly to the district court.
Mr. McNeil absolutely could, Your Honor. I think the important thing is that adds delay and uncertainty to the process. It would require him to begin again in the district court. If the district court doesn't, in our view, reach the correct decision, he has to come back up to this court where we would be presenting the same arguments that 2241 is authorized under the Savings Clause. In our view, the district court would be reversed. He'd go back down to the district court. All of this is adding time when his unconstitutional conviction is persisting unnecessarily. So we think that Ray Jones lays out a path that I would also say the application of the Savings Clause is sort of baked into the question presented on the motion for authorization. Fundamentally, the question is, does Mr. McNeil have an avenue to even have his claim of constitutional error considered? Whether that's under the Savings Clause or under the successive petitions the successive motions provisions, fundamentally the question is, when he is subject to a conviction for conduct that's no longer criminal, does he have any ability to get into court to have that considered? And we think the answer has.
Counsel, I'm sure, I know you've done incredible research in this case. I know that. So you know the judge who's talking to you now is probably the most sympathetic judge in the Fourth Circuit to Ray Aif and the issues you're broadly telling. You understand that? You understand how the case got to the Supreme Court and from this court and that?
I understand, Your Honor.
All right, so I'm a sympathetic voice to you, but you lost. But you keep saying something that I don't think is correct. You said he's now convicted of something, of conduct that's no longer illegal. That's not true. The conduct is still illegal to knowingly possess the weapon. The question is, there's an element that already existed that the Supreme Court said, I disagreed. I thought it was structural, that people ought not to be in jail for an element they didn't know about at all. I didn't prevail in that, at all. It went straight from this court, en banc and then on there. But it says it's not structural, and no one has agreed with you on that. So why do you say that it's conduct that is no longer illegal?
So I think in Rahafe itself, it points.
Conduct.
Yes, Your Honor.
It's a scienter element that's missing, not conduct.
Your Honor, there's language in Rahafe itself that says that scienter and conduct are inextricably intertwined, that the mens rea element is what separates innocent conduct from criminal conduct in many, many cases. If, there's a pen here between the two counsel tables and I pick it up with the intention of taking it home, whether that is criminal theft or not depends on whether I know that that pen doesn't belong to me. Whether separating conduct from, the Supreme Court has held separating conduct from mens rea just isn't the correct way to look at it when we're talking about whether there is conduct that's no longer criminal, or the other way that the Summerlin case addresses it is whether a person has fallen out of the class of individuals who can be constitutionally subject to a conviction under the statute. So prior to Rahafe, to be in that category of persons, all you had to do was know that you possess the firearm and have a prohibited status. Now, you have to know you have a firearm and know that you have that prohibited status. So defendants in Mr. McNeil's position have fallen out of the class of persons that are subject to a constitutional
Because they
conviction.
didn't know that they were a felon. He didn't know he was a felon. That's right.
Right, defendants who didn't know that they had a prohibited status.
Your client who didn't know he was a felon. They're falling out of that, right?
Yes, Your Honor. I think we haven't, on a successive petition is where Mr. McNeil would put in the facts to establish his knowledge or lack of knowledge of status. But yes, the government certainly hasn't proven his knowledge of status.
An opportunity to be able to show it in terms of what evidence he has, because Ray Aif wasn't as strong when it went back up in terms of the case. It's a different justice wrote it.
Yes, Your Honor. Yes, Your Honor. And I think you're hitting on something that's important, and I think it's the difference between the showing that Mr. McNeil would be required to make when he actually files in the district court versus the showing he's required to make here. And that's a minimal showing of possible merit warranting further exploration by the district court. And I think he's. We
start out, first the question whether or not Ray had raised the constitutional issue. Let's assume it does not. Therefore, you're in the savings clause realm. First question that comes to my mind is the jurisdictional one. Can you bring it here? Jones did so, but shouldn't you bring this down in the district court? You don't have a 2241 application before us. All we have is a motion for authorization to file a successive or second 2255 application. But then even if we do get to it, so that's where you are now dealing with the merits of a savings clause in light of Jones. Do you meet the Jones factors here? And that question would only arise if we determine it doesn't go back to the district court. Is that right?
I don't think so, Your Honor, but I may be misunderstanding the question.
You don't think so in what I described?
I don't think that question is only before the court.
What question?
I don't think the question of 2241's applicability is only before the court if Mr. McNeil has filed a 2241 application. I think it is baked into the...
You didn't file a 2241 application to us, did you?
No, Your Honor, that's right. So
That's the question. So if you're telling me you don't think it's before us, you're telling me Jones is not something we should follow. Jones wasn't there either, but the court went on and determined it under the
So I think...
clause, the various elements there. So what should we do here is the question.
The court should answer the question of whether Mr. McNeil has an avenue to have his claim of constitutional error considered under 2255. Either, our position is either that is under 2255H2, the successive petitions provision, or it's under 2255E, the savings clause. And a finding against Mr. McNeil on the issue of whether it's a new constitutional rule is inherent in that if under this court's precedent, he must have some ability to challenge this constitutional error, is the availability of savings clause relief. So it isn't required for the court to decide that, but I think it's baked into the question that's presented, and I think it also provides necessary guidance to lower courts for other defendants who may bring rehafe petitions. Thank you.
Thank you, Mr. Reisinger. Mr. Renfer?
Your Honors, thank you. May it please the Court, I'm Rudy Renfer, representing the United States in this matter. And our position is that Mr. McNeil fails to satisfy the threshold requirement to justify relief under 28 United States Code 2255H2, and that the case of the United States v. Rehafe did not create a rule of constitutional law.
Got two circuits agree with you, Black and Ray Val, and interpreting Bailey agrees with it. Is that where you're going with this?
Yes, Your Honor. Essentially, it's that. And I would like to also start out early on in my argument by noting, the United States did file a withdrawal of its argument regarding the retroactivity of Rehafe, and based upon the Graham decision issued yesterday, we also will not be arguing whether it is new or whether it was available to Mr. McNeil. The sole issue for this court is really whether Rehafe created a constitutional rule, and it simply did not. In Rehafe itself, the Supreme Court identified the issue as, quote, whether in prosecutions under 922G and 924A2, the government must prove that a defendant knows of his status as a person barred from possessing a firearm, end quote.
Constitutional rule. What about the savings clause?
About the savings clause,
How do we proceed with it? You know what they did in Jones, and you saw the Jones case. Is that something we should do? You don't need this court's authorization to do that. Go to district court and get that. So what should we do?
Your Honor, what you should do is deny his petition to file a successive 2255H2. That will be the end of the matter in the Fourth Circuit. Based upon this court's decision in Jones, Mr. McNeil will be able to file a 2241 petition regarding...
What it did in Jones, he could have done that there. In Jones, the court went on and analyzed it on the merits, didn't it?
Well, in Jones, yes, it did, but the little bit difference there is that Jones, if I recall correctly, dealt with Bailey and possession of a firearm. And it was clear in the record before the court at that time that the conduct for which Mr. Jones was convicted, on the record before the court, you could determine that the conduct for which he was convicted was no longer illegal. But we don't have that factual development of the record before the court in this case. In this case, Mr. McNeil needs to file his 2241 petition based upon Jones, but he needs to file that in the district court for the district court to engage in fact-finding to determine whether Mr. McNeil satisfies the savings clause.
You heard the Chief differentiate the difference between illegality and scienter. So what are we dealing with on that? You say the question here is whether the conduct was illegal. He can show that. The record shows that. Is that what needs to be shown?
What Mr. McNeil is going to have to show is that he did not know that he was a felon to qualify in order to establish that his possession of a firearm and him discharging it in a mobile home park with police nearby, that his act of doing that is no longer illegal because he didn't know he was a felon. But the district court needs to develop that factual record, that evidentiary record, to determine whether Mr. McNeil can make that showing.
So that's where it kind of gets confusing to me, is like, to what extent do we need to do that here?
I would,
Determining whether or not you can proceed to do it, and then ultimately whether the district court, this whole business, when you have a plain error type review and you got, it sort of shifts over. Kind of interesting to me how this thing flips around. First, the government's got to show it, and all of a sudden, if it's plain error, it flips it, I guess. But,
well, I
mean,
would,
for our purposes here, it seems to me where you're going is not somewhere we need to go. It may go there, but we're only dealing with these procedural motions here and applications, and it, at least Jones, in terms of it, did Jones make the ultimate determination?
the ultimate what Jones did is Jones opened a procedural vehicle for individuals to challenge their convictions when the relief isn't available under 2255. And this court set the standard for that with the 3 prongs of the Jones test. And I think other courts who have considered this issue have focused generally on the second prong. And in that prong is, can Mr. McNeil demonstrate to the district court that his conduct is no longer illegal? And that requires the development of the evidentiary record. Jones, while this court did issue an order to remand the case for him to file a 2241, number one, Jones was essentially a seminal case in this circuit that basically informed the district courts throughout this circuit how they need to proceed on savings clause petitions and 2241 petitions.
Well, it seems to me the question here is whether he satisfied the requirements to proceed with a savings clause application.
I don't think he needs to satisfy any requirements before this court. This court has already provided him all the authority he needs by way of the Jones case. And from my experience of handling petitions, I've been getting 2241 petitions citing Jones and arguing that it satisfies the gatekeeping procedure. And those cases have been developed in district court.
Just be filed directly with the district court, since you don't need our authorization to file a savings clause.
Correct. I think the 2241 needs to be filed directly with the district court, and that's what Mr. McNeil needs to do.
Jones sort of jumped the gun a little bit, you think?
I'm not sure what the court means by the jump the gun. I think what the court did is,
You should have sent it back to the district court and said, hey, does he have this? Let him file that application there.
but like I said, the distinction, I mentioned earlier, the distinction between Jones and this case, at least a clear distinction in my mind, is that there was evidence on the record before the court in Jones that the conduct for which he was convicted, which was possession of a firearm in furtherance of a drug trafficking crime, when the evidence before the record in the Jones case was that a search warrant was executed and the guns were found just in an apartment where drugs were located. And so that would be constructive possession at best, but under the law at the time, under Bailey at the time, that was sufficient for a 924C conviction. But this court had before it evidence on the record that the conduct for which Mr. Jones was convicted was mere possession or constructive possession at best, which blossomed into this 924C conviction. And on the record before the court in Jones, there was sufficient evidence for you to essentially remand it with instructions to follow this test. Here's the test that we have, and by the way, he satisfies it based upon our review of the record. But that evidence simply does not exist in this case. And that's what the district court is for. And, opposing counsel mentioned that this court ought to do it just as a matter of efficiency. But that's really not, the law can be inefficient sometimes, but the steps are there, and the steps are there to be followed. And in this case, this court has given the opportunity for inmates, for people convicted of crimes, to challenge those convictions via 2241 by arguing they do not satisfy, that they satisfy the 2255E savings clause, and by following the test followed in Jones. This court does not need to tell Mr. McNeil, you can go file a 2241. This court has already told Mr. McNeil that when it issued the Jones opinion. To the extent that he is asking this court to weigh in on the facts or weigh in on the evidence or weigh in on whether he satisfies the three-prong test in Jones, they're not asking for authorization to seek relief. They're asking for you folks to enter an advisory opinion that he is entitled to relief. And that's what the district court needs to consider first. Is there evidence in the record that shows that Mr. McNeil did not know that he was a felon, which would then satisfy, ostensibly, the second prong of the Jones test. And that would be the government's position. And that's with respect to the 2241. This court did mention also that going back to the constitutional rule issue, we would suggest that this court has done the same thing in the case mentioned by the court, and that's in re Vial. In the case, that was looking at the same Bailey case that Jones did. And Bailey, once again, was a case of statutory interpretation. And this court noted in Vial that the Bailey court clearly considered itself to be engaged in statutory construction rather than constitutional rulemaking. In fact, this court noted in Vial that the Bailey court neither referred to nor relied upon any provision of the Constitution as support for its holding.
So McNeil's conviction relied upon his knowledge of possession. Is that correct?
Yes, sir. At the time he was convicted, yes.
Where's the evidence of his knowledge of status?
Your Honor, before this court, there isn't any. I was a prosecutor on Mr.
You just told me we could find this illegal. Don't you have to show both knowledge of possession and knowledge of status to satisfy Rahif?
To satisfy, yes, Your Honor, yes.
You said there's no knowledge of status before us.
There's no evidence. I don't think there's any. There's no evidence that I'm sorry. Let me be more accurate. There's no evidence that he did not know he was a felon. There's none of that evidence before this court.
Well, that's knowledge of possession, which he was convicted of. But does he know of is there evidence of his knowledge of status?
Yes, Your Honor, the stipulation that he entered into a trial. He stipulated that he was a felon before the jury.
Did the government present that?
Yes, we did. We read it into the record. We read it into the record in open court, and that was with his consent and his attorney's consent and the judge's consent as well. And he made no objection. And I would like to point out that I know from my experience in the case that when he was sentenced and the convictions were listed in his pre-sentence report, he did not object to any of those convictions.
I admit that sounds close. I'm just trying to understand that because of what Rahif requires. It requires the government to come forth with the proof of it, that he actually knows this. Yes,
Your Honor, I'm spitballing here a little bit, but I would imagine that the United States, obviously will change.
Stipulate that he's a felon at the time of the conduct, or did he just stipulate at trial that he had been convicted of a felony?
No, he stipulated as to his status. He did not stipulate that that it was knowing.
Didn't use that word in there.
Excuse me, Your Honor?
Didn't use the word status, did he?
No, Your Honor. He stipulated that he was a convicted felon. He did not stipulate that he knew he was a convicted felon.
Was that stipulation published to the jury?
Yes, Your Honor. It was read into the record. And he made no objection at that time.
But you're saying he stipulated that he knew he was a felon at the time of the conduct.
If I said that, I apologize. I misspoke, Your Honor.
Isn't that what has to be established?
What does have to be established is that, yes, that he has to be, that he possessed it and that he knew his status as well. Yes, Your Honor.
Why is the second prong of Jones not satisfied?
I'm not saying the second prong of Jones is satisfied. I don't know if it's satisfied. That's what the district court needs to determine, is presented on evidence. What evidence is there, if the district court requires the United States to present affirmative evidence of his knowledge at a 2241 hearing, the United States can do that. Mr. McNeil, obviously, at that hearing will have to present evidence that he had no knowledge he was a felon. And from that evidence, the district court can determine whether Mr. McNeil satisfies the second prong of the Jones test, and then therefore would be entitled to relief. But all those questions are premature at this point, because of this.
Where I started this is because he's not filed here, do we just send it back? Because he's not filed a 2241 application here. But Jones actually went through this analysis.
Yes, Your Honor.
That's where I started on this. And then you took me down the path and said, well, it's already illegal here. And then we kind of worked it back to say, oh, no, we don't, he had to stipulate the status at the time of the conduct.
No, Your Honor, but if he is asking It seems to me that he is asking for authorization to file a 2241 based upon Rahif. And my argument is this court today does not need to grant Mr. McNeil that authorization. He already has authorization to file a 2241 with the language of 2241 itself. He has authorization.
That's why I started with this. Say, this sounds like to me, you could have just said, okay, yeah, that's what he should do.
That's absolutely, if,
We did point to Jones, and Jones creates a problem. I mean, you distinguish a bit with the Bailey and the whole bit. I think Jones creates a little problem. Jones actually went there, but the question is, did it have to?
I don't know that it had to, but it had evidence on the record from which it could render a decision. Because like I said, in Jones, the evidence was that that his conduct, the prong 2, was satisfied by evidence on the record. Because in Jones, he was convicted of possession, not use. And after Bailey, the evidence before the court was that conduct is no longer, based upon Bailey, that conduct is no longer illegal, and there's sufficient evidence on the record in Jones for this court to look at that and essentially, remand with instructions. But that same evidence, or the equivalent evidence, is not present in this case.
I thought you were arguing that if we issued an opinion denying his 2255 as successive, and then we say, without deciding, the petitioner may file a 2241 in the district court. And I thought your argument was that amounts to an advisory opinion.
I think it does amount to advisory opinion because there's nothing. I mean, I guess all you're doing is you're advising Mr. McNeil. This is what you can do, Mr. Huh? Yes, yes, sir, he can. But it's just I'd consider that to be.
Right now in court, what's the big deal if you put an opinion?
It's just an advisory opinion, Your Honor. I don't think this court needs to be issuing advisory opinions.
Issue a holding. It just said the district court can't do that.
Yes, Your Honor.
I've been through cases like this over and over with the court in which the government fails to do something. They make this point, the government can go back and do this and do that and do that. And I says, wait a minute. You're not the government. I'm telling my colleague, why you keep doing it? And now you standing here saying that we can't do it for him. We can't. You mean to tell me we can't tell the district court something that you know he can do, he knows he can do, we know? All we're saying is what everybody knows. You can go back to district court and file a 2241 application. And you call that an advisory opinion? That's not an advisory opinion. Advisory opinion would be if we went forth and just decided we're going to hold something that nobody's even brought up and it's not even holding it, not a part of the court.
If I could have a minute to explain what I mean.
But if it is an advisory opinion, maybe it's, you're helping me out. When the government is standing on the other side of this, you've heard it many times. I know you have. You see the cases where you bring a case to the government, you get an opinion that says, well, you didn't win on this, but you can go back and you ought to look at this and this and that. You've seen that.
Yes, Your Honor.
But that's not what's happening here. All that's happening is he's coming to court. We're now looking at the savings clause. He says, wait a minute, you don't need to come to this court for the application. You can go to district court. That's not advisory.
Your Honor, I would hark back to words that.
Why you even need to see it? I mean, what's the game one way or the other? Does it matter whether or not?
It doesn't matter, but there's something about opposing counsel's statement that lends itself to suggest he's looking more than just saying that you can do this. What he has said is this court should go ahead and essentially say that he is entitled to relief because his reason for doing that is if you go to district court and we lose, we're just going to bring it up to this court anyway. But if you go to district court and lose, you have a development of an evidentiary record.
I think you're worried about something you don't have to. I mean, we don't have any evidence in this record other than a request for successive 2255. There's no basis in fact upon which we can make a decision that would give him any relief.
Yes, Your Honor, and I appreciate the court's position, and I'll be silent on that issue. I was just trying to respond to what seemed to me his discussions of efficiency, and that this court should go ahead and make a ruling based upon efficiency. It seems that he wanted this court to engage in evidentiary findings because why waste time in the district court for their evidentiary findings when it's just going to be before this court anyway? So this court might as well make those evidentiary findings.
That inefficiency argument just doesn't carry any weight because he's known I don't know how long, but certainly a year or more, he could do this.
Yes, Your Honor.
2241. So if
Like I said,
he's the cause of the delay.
yes, sir. Now, like I said, I'm responding to his argument and what can flow from a natural inference from that argument. If the court doesn't read it that way, then, I'll quit with the advisory opinion argument, because really, this case is more about, since I think, we all agree that he's entitled to, or that he's allowed to file a 2241 seeking relief based upon the Jones case, that the main issue before this court then is did Rahif create a constitutional rule? And that was how everything got before this court to begin with, was seeking authorization to file a successive 2255 and trying to argue and establish that it was a constitutional rule. And I would just politely say that, all the other circuits that have considered this, and I know that there are two circuits in particular, but the Second Circuit, the Third Circuit, the Fifth Circuit, the Sixth Circuit, the Ninth Circuit, and 11th Circuit have all spoken on it. And each one of them have indicated that Rahif is a rule of statutory construction, not a constitutional rule. I would respectfully ask that this court hold the same and deny his petition for a successive 2255.
3 points, Your Honors. First, I think opposing counsel is conflating the standards between what is required for relief on a 2241 motion and whether a petitioner can file 2241 at all. To be clear, on the point of Mr. McNeil being the cause of delay, Mr. McNeil can't file a 2241 petition unless 2255 is unavailable to him, and it's his position that 2255 is available to him. Opposing counsel spoke several times about the factual record being insufficient. I want to be clear.
Available, then that's where the savings clause kick in.
Exactly, Your Honor. And I want to be clear.
I think you ought to move in the direction that Rahif didn't create a new constitutional rule. You want to continue to press it, it's fine with me, but it seems to me, I think you ought to do that. I like academic arguments. I'm telling you, I like to be dealing with stuff that's straight up, and because I think this case may turn on how we deal with the savings clause type issue here. And
Understood.
Which means you're not out. Maybe a different situation you got to deal with. But if you want to keep pressing something that every circuit has said no to, and there's nothing in this court that says you can do it, we do sometimes change our mind when we look at novel arguments and go back and restudy this thing. You could, we listen to the tapes of this and see how, what's going to come out of it.
So I want to be clear that we're not conceding our successive petition argument, but to address the savings clause argument, I want to be clear that prong 2 of the Jones test is not a factual test. It is not a factual question. It does not rely on evidence in the record. It is a legal question, whether the new rule has altered the category of conduct or the class of individuals who can be subject to a constitutional conviction. And so what Mr. McNeil is asking for in his alternative petition is to say, you satisfy the savings clause. You can file a 2241 petition. I've understood the government several times today to concede that he is free to file a 2241 petition, but they disputed that in their brief. They said he didn't satisfy prong 2. Now, prong 2 of the Jones test is just about whether you can file a 2241 petition at all. And the most common place that this court cites Jones is on appeal from denials of 2241 petitions dismissed on jurisdictional grounds that said you can't file a 2241 petition because you don't satisfy the savings clause. So what Mr. McNeil is asking for, assuming that Rahif did not announce a new constitutional rule, Mr. McNeil is asking for is this court to do what it did in Jones, to say, yes, Rahif errors do satisfy the savings clause because they're not because we've held that they're not new constitutional rules, and you satisfy the other requirements because if you are convicted without the government being required to prove your knowledge of status, then Section 2255 successive petitions provision is insufficient to allow you an opportunity to seek relief. So all we're asking for here is, which I understood the government to concede several times, is to say he does satisfy the savings clause and he can file a 2241 petition. Whether he's entitled to relief is a question for the district court, and we're not suggesting otherwise. What we're asking for here is, if Rahafe did not announce a new constitutional rule, that this court make clear to the district courts that Rahafe errors satisfy the Jones test, allow a savings clause avenue to a 2241 petition, so that we're not in a situation where a petitioner files 2241 without that guidance to the district court and has to come back up and press this Jones argument again.
That's what he's calling an advisory. That we don't need to do that. That's what you're saying.
I see my time's expired. Can I respond briefly?
You may.
We don't think it's an advisory opinion because it's baked into the question of whether 2255 provides relief, either under 2255H2 or 2255E. Thank you.
Thank you so much for your arguments. We'll come down to Greek Council and move on to our next case. Professor?
Thank you. Chief Judge Gregory, may it please the court. My name is Scott Ballinger. I'm the director of the Appellate Litigation Clinic at the University of Virginia School of Law, and it's my pleasure to introduce Sophia Evans, who will be presenting the opening argument for Mr. Elijah, and Hall Chasen, who will be handling the rebuttal.
Thank you. Counsel?
Thank you, Your Honors, and may it please the court. Appellant asks this court to do three things today. First, to reach the merits of Mr. Elijah's claim as opposed to simply remanding it. Second, to hold that Mr. Elijah is entitled to additional good conduct time credits pursuant to the First Step Act in connection with his original 108-month term of imprisonment. And third, to use its power to reopen Elijah's 2255 motion to find that he was sentenced in excess of his statutory maximum. On this first point, Elijah appreciates the warden's concession that at a minimum, remand is necessary to remedy the district court's error in failing to address his First Step Act claim on the merits. But remanding this case instead of addressing it on the merits would only serve to delay this court's consideration of this issue. More likely than not, Elijah will not prevail on this claim in the district court, as district courts have routinely rejected First Step Act arguments like Elijah's. Furthermore, remand would potentially have the effect of mooting Mr. Elijah's claim altogether. In addition, Elijah's request to have this court reopen his 2255 proceedings in order to address his second claim can only be considered by your honors, and the delay associated with remand here could potentially make it impossible for Mr. Elijah to receive full relief. Turning to the First Step Act claim, Elijah asks for nothing more than is due to him by Congress's own directive. To briefly review, the First Step Act, in part, amended the way good conduct time credits was calculated so that inmates could receive from 47 days per year to 54 days per year. All parties agree that Mr. Elijah is entitled to these additional credits vis-a-vis his revocation term. But the warden has failed to explain why Elijah should receive the additional good conduct time credits in connection with his revocation sentence, but not his underlying offense. The unitary sentencing framework established by the Supreme Court in Johnson and expounded upon by this court in Venable and Ketter all but dictate the outcome here. Excuse me. Precedent tells us that the original and revocation terms of imprisonment have to be treated as components of the same sentence. And Section 3624B1 states that a prisoner who is serving a term of imprisonment of more than 1 year may receive credit towards the service of the prisoner's sentence of up to 54 days per year of the prisoner's sentence imposed by the court. Combining these two pieces, it becomes clear that it doesn't matter that Elijah's term of imprisonment for his underlying offense has been completed. What's relevant is that his sentence is still ongoing. Indeed, Elijah is a prisoner who is serving a term of imprisonment of more than 1 year. He's serving the 144-month aggregated term of confinement in the eyes of BOP. Thus, he is statutorily eligible to receive credit towards the service of his sentence, not only for his revocation term of his sentence, but for the original term as well, since the two together form one unified sentence.
Counsel, you really think Congress intended to afford your client relief in that supervision revocation? Think about it this way. Why would Congress allow prisoners to bank credits and then they get released and then they go out and commit another crime? And they say, oh, by the way, I got some credit. I'm entitled to this.
Your Honor, we recognize that this would allow some inmates to bank time credits, but only a very small amount of time credits could be banked, not to the extent that we believe it could really affect a defendant's motive to recidivize. In this case, we think that here, Mr. Elijah would only be benefiting from the additional good conduct time credits. It would not affect his motive to recidivate or anything of that sort. Furthermore,
Think a little bit beyond recidivism here. Question that Judge Floyd is posing: why in the world would Congress do that? Allow someone to bank time. In other words, you haven't even committed something. We're going to give you, we're going to not send you to jail as long because of something that a previous time you got some good credit.
Your Honor, the very purpose of the First Step Act was to make the Fair Sentencing Act retroactive. And thus, Congress didn't need to imply this. It did make this retroactive by passing this. The whole way, the entire purpose of the First Step Act was to amend the way that good conduct time credit was calculated. And in doing that, they said that it applied to those previous offenses.
Any court in the nation supports the way in which you argue in this case?
I'm sorry, Your Honor?
Any court, is there any case out there that follows this line of reasoning that you're offering us today?
Yes, Your Honor, we think that Venable follows this line of reasoning, as the court in Venable said that because a revocation sentence is part of the penalty for a defendant's initial offense, he's still serving a sentence for a covered offense for purposes of the First Step Act. And in that case, you had to treat the defendant as if he were still serving the original custodial sentence.
A good time credit case?
No, Your Honor, it was...
How is it helpful?
It was different insofar as it was not a good conduct time credit case, but it was decided in connection with the First Step Act. And we think that the basic purpose of the First Step Act to make retroactive Congress's amendments in the Fair Sentencing Act is still what's at issue here.
So you're saying that basically no court has ever held it with regard to good time credits, the argument you're making today.
That's correct, Your Honor, but we believe that the courts that have come out the other way are merely citing policy, not really statutory interpretation, and have failed to provide an explanation as to why it should deviate from the unitary sentencing theory in deciding that issue. There's no good reason to treat revocation sentences differently from the original underlying offenses here in the context of good time credit. Thus, as a result, Elijah should be entitled to an additional 63 days of good conduct time credit, which is the 108 months, which is 9 years times 7 days for 63 days in total. Turning to Elijah's other claim, that he was sentenced in excess of his statutory maximum when he was sentenced to 36 months for the violation of his terms of supervised release, Elijah asks this court to use its power to reopen his 2255 motion to address this issue. Recognizing that this is an extraordinary remedy, appellant argues that this is an extraordinary set of facts. Here it was Elijah's contention that although he raised the statutory maximum claim originally, it was overlooked by the court and therefore went unaddressed. Though Elijah did raise this claim sufficiently to preserve it under the liberal pro se standard, it was admittedly obscured by his additional Hayman claim, which outlined an issue that has subsequently been resolved by this court and thus is not argued here. When Elijah was sentenced in 2007 in connection with his drug offense, the law at the time defined his offense as a Class B felony. But in 2010, the Fair Sentencing Act lowered the status of this offense to a Class C felony. Thus, in 2015, when he was sentenced to his revocation sentence, Elijah should have been sentenced in accordance with a Class B felony, or not a Class B felony, but rather a Class C felony. Section 3583E3, which outlines the relevant sentencing provisions, asserts that the maximum revocation sentence for a Class B felony is 36 months, but only 24 months for a Class C felony. Thus, in failing to prospectively give effect to the revisions made by Congress in the Fair Sentencing Act, the judge, in issuing Elijah's revocation sentence, failed to apply the law in effect at the time of his sentencing date, which constitutes a miscarriage of justice. Elijah agrees that the Fair Sentencing Act was not retroactive upon its passage. Indeed, the very reason Congress passed the First Step Act was to explicitly make the Fair Sentencing Act retroactive. Thus, Elijah agrees that he would not have been able to use the non-retroactive Fair Sentencing Act in 2015 to seek a reduction in his original sentence. What he's asking for is different here. He was entitled to have the current law applied at the time of his revocation sentence. A clear reading of the statute shows that the language is keyed to the present tense. It states that a prisoner who is a Class B felon or a Class C felon, and that's what Mr. Elijah is at the time of his sentencing event. This
So
court-
you rely, or at least cite, Haman, some authority to give you relief, but your client's been here before, and there was a finding by the district court and affirmed by the Court of Appeals that he's procedurally defaulted. What do you do with that?
You're correct, Your Honor, insofar as his original Haman claim has been decided under Costin in the meantime. What we're citing Haman for here is the proposition that the revocation term and the original term of imprisonment are two parts of the same sentence here. And thus, the original reason for why our client was citing Haman has changed as this court. We would love to make the Apprendi argument that we were going to make before this court has decided Costin, but that issue has been subsequently decided by this court. And thus, if there are no further questions, Your Honors, appellant respectfully asks this court to reverse and reopen Elijah's 2255 proceedings. Thank you, Your Honors.
Thank you, counsel. Counsel, Lee?
Chief Judge Gregory, may it please the court. I'm Andrew DeHall, and I represent Warden Richard Dunbar. We agree that Mr. Elijah's pro se objections to the R&R were sufficient to trigger de novo review, and we agree that the district court erred by not performing that task. We disagree, though, on the remedy. We disagree specifically that the remedy for that error is for this court to perform that task in the first instance, and also to reopen a separate appeal. We want to make something clear. We don't agree with the reply brief that this First Step Act claim presents a pure question of law. I've noticed today here at argument and then in the briefs, we keep hearing about the entitlement to these credits. I think the better term is on this First Step Act question is eligibility for additional credits. The First Step Act amendments to 3624B make someone who's eligible, or make someone eligible for an additional 7 days per year, but they're not necessarily guaranteed it. That's important here on this question of remand, because if the district court were to hold that Mr. Elijah is eligible, there would then need to be a calculation by BOP and an assessment of his conduct during his first prison term as to how much of those 63 days he would get. Now, that's more of a factual intensive inquiry, and so for that reason, we think it is important that the district court go and perform that analysis and consider this question in the first instance. As to whether this would become moot potentially, as I understand it, Mr. Elijah's current projected release date with the amount of good credit times he can get is November 15th, 2025, I believe. I want to just make that clear because the record, or the JA talks about him having that release date in September 2025, but it's actually been pushed back. So he's got 2.5 years to have a court, and potentially this court, look at it. Now, as for the remand having an impact on his request to reopen his 2255, I think that just speaks to why this argument shouldn't have been made in this appeal in the first place. If he really wants the mandate to be recalled in that appeal, that motion should be made within that appeal and not in this one. And because it could be done there, remanding would not prejudice him or delay his ability to try and pursue those arguments within that case.
I think the most likely reason for remand is that that his objections were not appropriately considered. And so can we not dodge all this good time credit by just sending it back for the court to consider the objections appropriately?
That's correct, Judge Floyd. I mean, and that's what we're advocating here, is that this be remanded to the district court so that it performs the analysis that it was supposed to, and so that Mr. Elijah gets the Article 3 adjudication of which he complains in his opening brief. Now, assuming Your Honors disagree with me about that, I'm happy to address the merits of the First Step Act claim. And I think it's important to know precisely what the First Step Act did to 3624B.
I asked you about the Venable decision. That's a case that used the unitary sentencing framework to interpret the sentence under the First Step Act. How is that distinguishable from this case?
As Your Honor pointed out when Appellant's counsel was arguing, that's not a good time credits case. That is about the sentencing power of a district court. And we submit that there's a distinction between using the unitary sentencing theory in court proceedings versus using it in a statute designed for BOP to administer. So we think that is a key distinction, and why Venable would not control the result that Mr. Elijah wants here. And on that point, I think if I understood my friend on the other side, she said that the First Step Act's purpose was making the Fair Sentencing Act retroactive. Now that was true as for part of the First Step Act. I think it's important here to see exactly what the First Step Act in Section 102 was doing. And as counsel correctly identified, the whole point of that part of the First Step Act was simply to change the formula that resulted from the Barber versus Thomas decision by the Supreme Court in 2010, such that prisoners could get the full 54 days instead of 47. Now, what Congress didn't do was change the nature of these credits. They didn't make these credits, which hadn't been bankable since the Prison Litigation Reform Act in 1997, somehow bankable for people who go out and commit a supervised release violation. And so when I read these decisions that we have cited in our brief, I don't see them or the argument I'm making here against banking about my policy or these courts' policy, but really about interpreting Congress's policy. Did Congress intend to change this?
Does that go to whether or not this situation is a covered offense? In other words, is a revocation a covered offense under the Act?
I read Venable that way, yes, Your Honor. I think that is, Venable says that. Your Honors, if there are any other questions about the First Step Act claim, I'm happy to answer them, but if not, I'll go ahead and proceed to his request to reopen the 2255 proceedings. Again, we start out by saying that we disagree that this is the appropriate case in which to try and reopen that decision, which was handed down in 2021. If he's going to do it at all, he needs to make a motion within that case. Second, we disagree that the last resort style nature of recalling the mandate is appropriate in this case. We think that he has thoroughly litigated his claim in the district court and before your honors. He even petitioned for panel and en banc rehearing. And so we think that that's not something that needs to be further litigated, and that he hasn't met the standard for the extraordinary relief he requires. Your honors, if there are no further questions, we ask that this matter be remanded to the district court.
So you believe that the sentence he received was correct?
The 3-year revocation?
For the violation?
We do, your honor.
Although it really should have been C?
We don't believe that it should have been C, your honor. We think that he was sentenced in 2007. It was a Class B felony at that time. He was sentenced before the Fair Sentencing Act took place, and the Fair Sentencing Act doesn't apply to people who were sentenced before August 3rd, I think, 2010.
If you're wrong about that, the sentence was wrong.
Yes. Thank you, your honor.
All right, thank you. Thank you, counsel. Counsel?
Thank you, Your Honors. I'd like to make 3 points. With respect to whether or not this court should remand the case, we think this case is distinguishable from Cruz. In Cruz, there was new factual determinations that arose between the magistrate's report and recommendation and the district court's opinion. And so in that case, it was appropriate for this court to remand for the district court to make a decision. Here, all that's presented is a legal question, and this court routinely decides questions of law in the first instance. And we think that in the interests of both efficiency and justice, because all the district courts that have considered Mr. Elijah's argument, as the government pointed out in their 11-case string cite, have decided against him, and we think because they are misapplying this court's unitary sentencing theory as it was set out in Venable. By deciding this question here now, this court will provide instruction to the district courts how to decide this issue going forward and clarify this court's unitary sentencing rather than waiting for Mr. Elijah to go through the remand process, lose, bring another appeal, and so forth, at which time he could very well already be released from prison, depending on how long that process takes. And with respect to whether or not Elijah is entitled to the good conduct time, it's already been established that he's entitled to those credits by virtue of the First Step Act being retroactive. The question now is whether he is statutorily entitled to apply them to his sentence. And we would argue that he is, because under this court's theory of unitary sentencing, the revocation sentence that he is currently serving in his 144-month term of imprisonment is a part and tied to that original sentence. And so he is able then under the statute to apply those good conduct time credits that he earned to his revocation sentence. With respect to whether or not we're asking this court to apply the Fair Sentencing Act retroactively, we are not. Congress did not need to make the good conduct time of the First Step Act retroactive, but it did. And we are simply asking this court to apply it in that way. And I think on that point, we think that Elijah should get those good conduct time credits. And with respect to our second argument that this court reopen his 2255 petition, we do acknowledge that this is an extraordinary request and it's an extraordinary form of relief. But with respect to whether or not we're asking for a retroactive application, we're not. The Fair Sentencing Act does not apply retroactively. We concede that. But it does apply prospectively at the time of sentencing. And when Mr. Elijah was sentenced to his revocation sentence in 2015, he was subject to the Fair Sentencing Act. And the law in 3583E3 at the time is someone who is convicted of a Class C felony is subject to only 2 years of revocation sentence versus a Class B subject to 3 years. And this court in United States versus Hope followed the Supreme Court in Dorsey versus United States by applying the law as it is at the time of sentencing. So we're not asking for a retroactive application of the Fair Sentencing Act. We're simply saying that the district court did not apply the law that was in effect at the time to Mr. Elijah's revocation sentence, and it should have, because the statute says is a Class C felony, is a Class B felony. And if there are no further questions, Your Honor, we would ask that this court reverse and reopen Mr. Elijah's 2255 petition for further proceedings. Thank you.
Thank you, counsel. We note, Professor, that your court opponent, on behalf of the Fourth Circuit, we thank you and Learned Student Council for being here. We need lawyers like yourselves to take these cases and help us on these thorny issues. Thank you so much. Of course, Mr. Hall, we thank you for your able representation as well. With that, we're going to take a very brief recess and come down and greet counsel. And the clerk will give instructions to the audience. Thank you.
This honorable